Can the insurance company reduce my settlement because I have health insurance under Connecticut's Section 52225A? If your health insurance paid your medical bills after an injury, you may wonder whether that reduces what you recover in a Connecticut personal injury case. Connecticut law allows courts to reduce the economic damages portion of a verdict by certain collateral source payments after trial. This rule is found in Connecticut General Statutes Section 52225A. The statute applies after a jury awards damages but before the court enters final judgment. The purpose is to prevent what the law calls a double recovery. A double recovery happens when an injured person receives insurance payments and also recovers the full amount of those same medical expenses from a jury verdict. The reduction applies only to economic damages. Economic damages include medical expenses, lost wages, and other financial losses with specific dollar amounts. Non-economic damages, such as pain and suffering, are not reduced under Section 52225A. If your case settles instead of going to trial, the court does not hold a collateral source hearing. However, defendants and insurance companies may still consider potential reductions during settlement negotiations. When a case goes to trial, the jury sees the full amount of the medical bills. The jury does not hear evidence about which bills were paid by health insurance. After the verdict, the defendant can request a collateral source hearing. At that hearing, the judge determines the total amount of collateral source payments. Collateral sources include payments from private health insurance, Medicare Advantage plans, and medical payments coverage under auto insurance policies. Life insurance benefits, settlements from other cases, wage continuation payments, and Social Security disability benefits are not considered collateral sources under the statute. The court focuses on the amount actually paid by the insurer. If a medical provider voluntarily forgives part of a bill, that forgiven amount is not treated as a collateral source payment. The judge follows a two-step process under Section 52225A. First, the court calculates the total amount paid by collateral sources for economic damages. Second, the court subtracts the total amount of insurance premiums paid to secure that coverage. Premiums paid by you count toward this offset. Premiums paid by your immediate family members also count. Connecticut courts have clarified that employer-paid premiums count as payments made on your behalf. This means that even if you did not directly write the check for the premiums, those amounts can reduce the net collateral source reduction. For example, if your health insurer paid $30,000 in medical bills and $25,000 in premiums were paid during the relevant period, the net reduction would be $5,000. Only that net amount is subtracted from the economic damages award. There is an important exception involving subrogation rights. Under Section 52225A, there is no reduction for any collateral source that has a right of subrogation. Subrogation means the insurance company has a legal right to seek reimbursement from your recovery. Many health plans, including certain self-funded ERISA plans, include reimbursement or subrogation language. Medicare and Medicaid also maintain subrogation rights under federal and state law. If a valid right of reimbursement exists, the court does not apply a collateral source reduction for that source. In that situation, you receive the full jury award for economic damages. The insurer may then assert its lien separately to recover what it paid. The Connecticut Supreme Court in Marciano v. Jimenez confirmed that when any valid right of reimbursement exists, no collateral source reduction is allowed for that source. This rule can significantly affect the value of a personal injury case. Insurance adjusters often consider potential collateral source reductions when evaluating settlement offers. Understanding how premiums and subrogation rights apply can help you assess whether an offer fairly compensates your losses. If you are partially at fault for your injuries, Connecticut's comparative fault rule may also reduce your award. The collateral source reduction cannot exceed the amount of economic damages remaining after any comparative fault reduction. These calculations can become complex in cases involving multiple insurance policies. A personal injury lawyer can review your insurance documents and identify subrogation clauses that may prevent a reduction. An experienced attorney can also gather documentation of premiums paid and present that evidence at a collateral source hearing. At DeFronzo Petroskey, P.C., a Waterbury personal injury law firm, Dan Petroskey has represented injured clients across Connecticut since 2004. This law firm handles car accidents, slip and fall cases, premises liability claims, and dog bite cases. The firm prepares for collateral source hearings by collecting insurance records, calculating premium offsets, and presenting evidence in court. If you are facing significant medical bills and questions about how insurance affects your recovery, speaking with a lawyer can clarify your options. An attorney can help you understand how Section 52225 may apply to your specific case. DeFronzo Petroskey, P.C. can be reached at 203-756-7408 at 255 Bank Street, No. 2B, Waterbury, Connecticut, 06702, United States.